In this video, I'll be talking about special immigrant juveniles. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Let's get right into it. What are the qualifications? Who's actually qualified to petition as a special immigrant juvenile? We never talked about it before. I think we've talked about it like a long time ago, but not in too much details. But today we are going to be explaining some of those qualifications so that you might help yourself or help somebody that you might know, okay? Eligibility for special immigrant juvenile. When we apply, we use the form 360, I-360. That's the form we use when we apply. So let's get right into it. First of all, the person must be under 20 years old of age. And when? Only at the time you file the application, you must be under 21-year-old of age, okay? That's qualification number one. Qualification number two, the person must be living in the United States. The person cannot apply from outside of the United States, okay? And when that happens is that by the time you're applying to the time that USCIS makes its decision, you must be in the United States. Qualification number three is that the person must be unmarried, not married, okay? Because we're talking about special immigrant juvenile. So you must be unmarried to be considered juvenile, okay? So it's either you have never been married or you previously got married, but the marriage ended in divorce, death, or annulment, okay? So basically, and that is when at the time you apply and until USCIS makes its final decision. Then we go to qualification number four. You must have a juvenile court order issued by a state, okay? And the court in the United States must find that you are a dependent on the court or in the custody of a state agency. And then you cannot be reunited with your family for any of the following reasons. Because remember, you're applying on your own because of that. You must have that court order. And the court must find that you cannot be reunited with your family for the following reasons: abuse, abandonment, neglect, or similar basis under the state law. Remember that I am doing family law. I'm taking family matters in DC court. So if you happen to be my client, when we're talking about applying for special immigrant juvenile, and you want to get your court order determination in the District of Columbia juvenile court or family court, of course, you can also contact me as well, because at this moment, then I will be handling, first of all, trying to get you that court order, and then go ahead and apply for that special immigrant juvenile using the petition form I-360, okay? So, and then I believe this is the fifth eligibility criteria, is that you must be eligible for USCIS consent, okay? What that means, it means that you must have sought the juvenile court order to obtain relief from abuse, neglect, or abandonment, or similar basis under the state law, and not primarily to obtain an immigration benefit, okay? So this is where it gets tricky, right? Some people they know that they can qualify under basically under this petition, special immigrant juveniles, then they go ahead and start accusing people for abuse where there's no abuse, in order for them to get that court order and come back here later on with the immigration system, USCIS, to apply for this petition. So remember that it cannot work like that. It has to be legit. So that's why USCIS has to give their consent. So you must be eligible for consent. So they have to find out that you didn't have ulterior motives, okay? So, and this at the time USCIS makes a decision. So what else I wanted to mention about the juvenile court order. So that order has to be both at the time you file the petition and at the time USCIS makes a decision. But there is an exception that says that you do not need to currently be under the same jurisdiction of the juvenile court that issued your order if the court jurisdiction ended solely because you were adopted or placed into a guardianship with other people. So, or you age out of the juvenile court jurisdiction, okay? Then the last criteria will be that you have a written consent from the Department of Health and Human Services, Office of Refugee Resettlement. You are currently in the custody of HHS, and the juvenile court order also changes your custody or replacement at the time USCIS makes decision on your petition. So what I want to say about this one, the special immigrant juvenile, it's really, you have to be having a lawyer to handle this, because you cannot handle this on your own. First of all, you cannot represent yourself in juvenile court. Some people try, but really I will strongly advise you against it. So you go get your court order based on abuse, neglect, abandonment, or any other similarly basically issues under that state law. And if you happen to be in the District of Columbia, so you can contact me as well so that we can handle that representation in juvenile court, so we can get you out of it, out of that abusive situation. Then go back to USCIS with that court order and apply for the Form I-360, provided that you meet all those other requirements. Okay, this is a little bit complicated than any other type of petitions, because we're following two paths at the same time. Or you gotta follow one and get it straight first before we come back to USCIS. You really have to contact somebody who has the knowledge to help you out in that case, okay? If you need a consultation with me, or if you know somebody who might need a consultation with me, please do not hesitate to give them my number, 202-751-2180. Email on display. Until next time, bye-bye.